Justice Sotomayor?
I am a little confused. Assume that I want to enter a transaction and the other side says, I won't do it. If you have been in cahoots with someone who's part of this decision-making, isn't the essence of my bargain that I gave you this contract and you took my money? You perform services, but I wouldn't have entered this contract with you. And it's very clear. I've said it to you.
Mm-hmm. And you would have an excellent action in breach of contract, Justice Sotomayor. You would have potentially—
Why isn't that false pretenses? Which is what the argument— you call it fraudulent inducement, but the government calls it a common law false pretenses case.
I think the government calls it fraudulent inducement, and we and the government have disagreed on what fraudulent pretenses at common law required. We think that it does require some form of a loss. The government has countered with citations that it thinks supports the opposite. One of the problems with this court trying to resolve complicated issues of common law when the parties only raise the issue in the respondent's brief and then reply briefs is that the court doesn't have a full foundation of the literally hundreds of common law cases that address this. But our view would be there might be some other offense, there might be some civil action, almost certainly would, but the requisites for a criminal conviction, and in this case one that carries 20 years in prison, are not met for every misstatement in a contract, every false statement that the government—
I didn't say every false statement or misstatement, a material one.
True. And the government would substitute yet a different materiality standard from the one that this court has said in an effort to limit the reach of its fraudulent inducement theory, because taken at face value, there are hundreds of cases that are litigated in state courts every year on a fraudulent inducement theory. And under the government's theory, they are all federal crimes, at least if the government can show its new essence of the bargain requirement and its by means of requirement. And that has never been the way that fraud prosecutions have previously proceeded. Every single case in this court is either a something for nothing fraud
We're
or
back
something—
to we shouldn't get into this.
I would entirely encourage the court not to get into it and to decide instead the question presented.
Justice Kagan?